Okay.
All right, so it's a little after 5. Let's call the meeting to order. This is the Ethics Board for the City of Green Bay for Wednesday, July 22nd, 2020 at a little after 5. I believe you should all have the agenda before you. So the first item of business would be a roll call. I believe that's automatically recorded, so we should have that. We check just to see, because it looks like we have a quorum.
Yes, we do.
Yes, okay, so we have a quorum. Item C on the agenda is approval of the agenda for tonight's meeting. Is there a motion to approve?
Motion to approve.
Okay, we have a motion, and is there a second?
Second, Aaron.
All right, we have a motion and a second. Any additions to the agenda? Otherwise, all in favor?
Alder Vanderkast, I'm sorry, I did it again. Can you just be an alder for tonight?
Sure.
Could I just have you slow down just a little bit? I'm still getting used to doing these in
Sure.
In Civic Clerk, so I just have to make sure I'm recording the motions correctly. That was, why can't I see? Okay, so the motion was by Cheryl and it was seconded by Aaron, is that right?
Correct.
Thank you. Hold on for just 1 second. Bear with me, please.
No problem.
Sorry about that, technical difficulties on my end. You can go ahead and vote on that one.
All right, so all in favor of approval of the agenda for tonight's meeting signify by saying aye or clicking yes.
Aye.
Aye. Aye.
Aye.
Any opposed? Opposition, motion carries. So the agenda is approved. We'll move on to item D, approval of the minutes. So is there a motion to approve the minutes from the February 26th, 2020 Ethics Board meeting?
So moved.
A motion, and I will second. Any additions, corrections, or modifications to that set of minutes? Hearing none. All in favor, signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. All right, moving on to item E, under regular business. The first item is a hearing on ethics complaint against Alder John Vanderleest filed by Mr. Tarl Knight under the City of Green Bay Code of Conduct for Elected Officials. So we have a hearing scheduled for tonight, but as you probably all seen, there were a number of documents filed by Alder Vanderleest's attorney, Mr. Miller, this morning or yesterday, excuse me, and then also that Mr. Knight had filed some additional documents as well. My recommendation would be to give everybody a chance to analyze those documents that were filed, that we schedule this down the road a couple of weeks for a hearing. That would be somewhat consistent with Attorney Miller's request for an adjournment for more time to investigate and review this on behalf of his client, Alder Vanderleest. And I certainly personally have no objection to that. But I think because these documents were filed today or within the last 24 hours or so, that we ought to make sure that both sides get all the documents that have been filed and have a chance to review and analyze them. Anybody else have any thoughts on that? Yeah, Bill.
Sure. Seen Mr. Knight's documents that were filed. I received an email earlier today and I was able to look them over. The paperwork that Alder Vanderleest attorney filed, that was done this morning?
I saw it this morning. It might have come in yesterday afternoon or sometime yesterday.
I'm gonna have to check again because I haven't seen those. And unfortunately though, I've had close to 400 emails in the last 5 days on another minor matter. But I guess my concern is, and I'm not sure, how long has this issue been on the docket now for us? Does anyone know?
This is the first time that it's come up. So the complaint was filed several weeks ago because of the work from home kind of setup that's been going on here at City Hall. It took a little bit for it to get to my office. The complainant, Mr. Knight, has been understanding and accommodating about getting the hearing scheduled as quickly as possible in light of that delay. So this is the first hearing on the matter. And the first motion from Attorney Miller was filed on Monday. The second was filed yesterday, but I did send them both together yesterday. So I imagine, Alder Galvin, that was amidst just a couple other emails that you were getting, like you said.
Yeah, okay. So I guess what I'm asking though is when was Alder Vanderleest and Mr. Knight aware that this would be going to the ethics meeting? I mean, when it's all said and done, were they notified like a week ago, 2 weeks ago, 3 weeks ago?
I believe Haley, who does the scheduling for ethics, started reaching out, I want to say 2 or so weeks ago.
Okay.
The date was finalized early last week.
Okay, and I'm not trying to be a pain. I just, we've had other things on ethics get carried out so long that people were forgetting nuances and facts, things like that, because it took so long to finally get to a hearing. I just want to make sure we're not going to start running into delays that are going to set this thing so that we're finally hearing it maybe next year, I guess is my concern. So I just want to make sure there's some things in place, some metrics in place, some measurable metrics that we can say that, okay, you know, we need a couple of weeks to digest the material we received from both parties. But we're definitely going to have a hearing, barring nothing else occurring in the world or in Green Bay within a certain date, so that this thing can be, you know, can come to a conclusion so everyone can get this done and get it behind them. I guess that's my thrust here. Thank you.
My initial thoughts on this was to try to schedule it out about, well, from my schedule, I'm pretty well tied up next week. So I was thinking at least 2 weeks. But in reviewing the documents that Attorney Miller submitted, he raised a couple of issues that I'm not sure we've addressed before. And that was the issue about subpoenaing witnesses, and also it looked like he might be looking for some depositions or to take some depositions. And again, we've not dealt with that issue before. I know that there are provisions in the Code of Conduct dealing with subpoenaing witnesses and so forth, but I'm not sure there's anything in there about parties taking depositions before the hearing. And I guess that's a matter that we would need to refer back to legal counsel for an opinion as to whether that's covered under the Code of Conduct and whether we have authority to order that or not. I don't know. And so that's an issue that I think needs to be addressed. So we need to take that into consideration here as we try to schedule this, because if there are going to be depositions, that may require us to push this out even further.
Attorney Zamnick, this is Vanessa Chavez. So in administrative hearings such as this, discovery is not allowed for or provided for Instead, the parties are encouraged to fully and freely exchange information. The rules of discovery and the rules of evidence don't apply. They're instructive, but they don't apply in administrative proceedings.
I would have said that too.
So
I
does-
agree.
So does that mean as much as he wants to have discovery, as much as he wants to have depositions, that's just, we're not built to handle that, so it'll all have to take place at the actual hearing?
Well, that doesn't mean that they shouldn't be just providing information beforehand, especially because the burden. So let me explain. Let me back up. So in proceedings such as this, the burden of proof is on the plaintiff to demonstrate that the allegations occurred, not on the defendant to demonstrate that they didn't. And so the burden of proof is on that person, not on the respondent, essentially. So with that, the rules of evidence just generally don't apply. That doesn't mean that we can't choose to adopt them, but we haven't. Second, we don't have subpoena powers or attorney subpoena powers. This ordinance provides for subpoenas to compel attendance of witnesses, meaning that you can require people to show up and actually testify here, but nothing's contemplated by the ordinance to allow us to have subpoena powers for people to depose each other in these proceedings. So the original complaint is supposed to specify or lay out with specificity what the actions complained of are, so that the person who is receiving the complaint is able to prepare a defense, because these are supposed to be personal to them. It's not anything. It's a claim that they personally did something in these allegations. So that is one of the other reasons that discovery just generally isn't available. What I would say would be appropriate is to determine at this point whether the allegations are sufficient for the person, or for Mr. Vanderleest, I should say, to be able to determine whether or to respond to it. And if there are any allegations that are listed that are not adequate, then I don't see any reason in saying those are stricken.
Okay.
And as sharing of information, would that mean that the material that Mr. Knight, we were given today would be given to Alder Vanderleest, and anything that Alder Vanderleest has for his defense would be given to Mr. Knight by Mr. Vanderleest, so that they could both review it prior to the hearing?
Yes.
Okay. And can we make them do that, or we're just asking them to be nice guys and share?
Anything that's going to be presented to this committee, we can tell them they need to share it ahead of time. I don't see any issue with that. But as far as compelling somebody to actually testify, compel them to provide information that they weren't otherwise going to rely on, we don't have that power.
Okay, so if, say, Alder Vanderleest wanted to question some of the people listed in the complaint that Mr. Knight has made, we can't compel them to show up at the hearing, or if they're even there, we cannot compel them to say anything about what occurred.
We can compel them to show up day of. What we can't do is make them. Okay, so subpoenas are slightly different from a deposition. So we could require them to show up to actually testify before the board. What we can't do is tell them they have to show up and answer questions for the attorneys ahead of time.
Okay. Okay. All right. So, all right. Thank you very much. I appreciate the explanations.
I would just add or ask for an additional kind of clarification along those lines. The subpoenas to require a party to show up at the hearing, that's something that the parties would have to make the request for. Is that correct?
Generally, yes.
Yeah. Okay. So it wouldn't be us as the board making a decision to start calling or not calling people.
No, no. So really what we would expect we would compel the attendance of the parties themselves. And then the witnesses are who they anticipate will be speaking. But like I said, it's really up, the burden is on the person who brings the complaint to demonstrate that the person did what they said. And so they're going to need the testimony, witnesses or documents or something. So if they're not producing it, there's nothing for the other person to respond to because no evidence being provided.
So if one of the parties wanted to subpoena a witness to appear and testify, what would be the process for them to do that or to get that subpoena?
I'll have to look into this so that we can make sure that that process is followed properly, because we have not run into this before, and we want to make sure that whatever we're doing now is going to be possible to move forward with.
I was just trying to figure out what the protocol would be. Would they act with the ethics board, and then as chair, I'd have to sign the subpoena, or would it go through your office for them to for your office to issue the subpoena? That's what that's kind of the format that I'm looking for, so that the parties know what the process would be.
And I have to go back and look at our ordinance to make sure to make sure that what we're doing is going to be sound with it. I don't have that information.
When you do that, could you shoot get a memo out to all of us, including the parties, as to what that process would be if they'd like to subpoena somebody?
Sure.
Okay. All right. All right. So we are at the point, I think, unless there's any other questions, of trying to pick a date for a hearing. Does anybody have anybody from the board have any other questions before we move to that step?
I have one quick question. There was an issue of standing raised by Alder Vanderleest's attorney. Is that relevant? And I don't think you have to be personally injured to file an ethics complaint against somebody. So my sense is that the standing issue does not prohibit Mr. Knight from moving forward. Is that an accurate interpretation?
It's really up to the board to determine whether or not that's the interpretation of the ethics and code of conduct.
Okay. So that's an issue that would be it would need to be addressed before we got to the actual hearing component of this complaint as to whether they're standing to proceed. Vanessa, how do you suggest we consider that?
We can consider that either, so there's a couple of things we could do. The board could accept briefs on that issue. Otherwise, the board could ask staff to make that not make the determination. I'm sorry, that's the wrong word. To do the research on that and bring it back to determine whether or not standing is when it applies, and then it can be applied. So it's up to the board on whether you want it to be based on briefings or if you want independent research from council.
My suggestion would be that we start by setting a date when the parties can file briefs as to the issue of standing, and then backing it up from that, a period of time after that for the law office to respond to those briefs and advise the board accordingly, and then we would set the hearing date at a time after that. Anybody have any issue with that? All right, so I think the first issue then is setting a date for the parties to address the standing issue that's been raised by Attorney Miller. Um,
I'm in the meeting right now.
I would suggest that we push this out. I can't imagine it's going to be that complicated of an issue to address. So I would suggest maybe 2 weeks for council or for the parties to submit their briefs to the city attorney's office on the issue of standing. Anybody have any thoughts on or comments on that?
Are we talking like the first week of August then, or the second full week of August?
I would say that second, well, 2 weeks from today, let's say 2 weeks from tomorrow.
Okay. So we're looking at the 13th of August.
Right.
I'm actually free, especially with today's.
Well, that date wouldn't be for us. That would be for the parties to submit their
Okay.
position on standing.
If I can interject really quickly, 2 weeks from tomorrow would be August 6th.
Okay. And then we could get together a week after that?
I think the city attorney's office is going to need some time to evaluate those briefs and then provide us with a position.
Okay, so the week of the 17th through 21st?
Hello, this is Rob Miller. Could I be heard on this stuff? I was out of the meeting for a while. I was bumped out.
Right. So let's, is there a motion to open the floor?
Motion to open the floor.
Second.
All right. All in favor of opening the floor for Attorney Miller, please signify by saying aye.
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 Aye. Any opposed?
Okay,
Motion carries.
okay, thank you. First off, I was bumped off once somebody, I think one of the assistant city attorneys was saying there's no opportunity for discoveries. So everything that happened since then, I didn't hear. But my point is we have to conduct some discovery because the complaint basically is conclusory. And I'm not sure that Mr. Knight, and parenthetically, I've not seen Mr. Knight's recent filings. They were not sent to me. Mr. Knight comes up with some conclusions and then lists 4 or 5 people that have some knowledge of deleted posts and or blocking. We unequivocally deny any blocking and suggest that any deleted posts were done as a matter of eliminating reprehensible statements. So in order to actually get the facts in this question, in this matter, either those parties should be asked to submit a complaint outlining what happened in the specific time or date, or we have to be able to conduct some depositions of the people as to what happened. There's nothing in this complaint with regard to what was deleted or what is alleged to have been blocked. In fact, I'm not sure whether Mr. Knight actually has any personal knowledge of the facts here. It's entirely possible that he's reciting what other people told him, and I think it's been a matter of law for about 500 years that we don't convict people on the basis of hearsay. I can't cross-examine pieces of paper. So if the board would ask that the people that are mentioned specifically state what happened when.
Oh, shit. Sorry.
Hello.
I'm so sorry, Attorney Miller. I hit the wrong button. I cut you off right there. If you could
Oh,
just
okay.
re-say
Well,
that last comment.
been sort of a nightmare with this Zoom meeting tonight. But my point is we're entitled to a notice of what the claims are, and at this point, there's a large recitation of a legal analysis, some of which, or much of which I think is incorrect. But we need to have some recitation of the facts. What do these people allegedly experience? When did it happen? And that sort of thing. And that's not present in the complaint as constituted. And it's entirely possible that Mr. Knight as just taking their information and putting it in the complaint. So that troubles me. I can't very well be asked to defend a client when we don't have adequate notice of the from the people that were actually allegedly aggrieved, and when and where it happened. So that's why I need an opportunity to prepare this, and I've cited the leading case with regard to administrative hearings, Goldberg versus Kelly, basically according people in administrative hearings a right to discovery. I take this very seriously. My clients spent 71 years producing his reputation, and I don't think it should be damaged willy-nilly without an opportunity to find out exactly what the people listed are complaining. I don't think that's too much to ask. And as far as, I know there was some discussion as to when this was given to us. I've been in the case for about 3 or 4 days. I saw the material transmitted to my client, I think, about 10 days ago. So given the stakes with regard to my client's reputation, I think it's quite reasonable to be given to have his attorney given his attorney an opportunity to produce a defense. And right now, it's just in the realm of absolute hearsay, as I indicated in my filings, some of which were actually filed on Friday. This is a legal thicket with a constitutional quicksand, and we maintain that my client was entitled to delete tasteless posts pursuant to a Communications Decency Act, which was appended to my materials.
Attorney Miller,
Yeah.
I understand your point. We're not going to get into the substance of this at this point. We're just trying to deal with some procedural things. So the first thing that we dealt with, and I don't know if you caught all of this or not, but the first thing that the last thing we just got done dealing with before we opened the floor was the question of the issue of standing that you raised. And the proposal that was made is that the parties be given 2 weeks to address to brief the standing issue under the Code of Conduct, and then the city's law department would have a week to 10 days or so to review those briefs and provide and advise the board accordingly. You've also raised the issue of discovery. And we had a brief discussion, and I don't know if you were online or involved at that point, but the discussion was the issue of discovery in the proceedings under the Code of Conduct. So it looks like we've got some issues with that may need to be addressed as well, to make sure everybody gets the opportunity to address all their concerns. One of the concerns that was expressed was whether this board has the authority to compel someone to show up for a deposition. We've not had that come up before. I reviewed the Code of Conduct, and I found no direction on that. So again, that's another issue that I think ought to be addressed by the parties, and have the law department again advise us accordingly as to whether there should be any discovery. So I understand your concerns. We're trying to address all those concerns, while at the same time recognizing that this matter has been pending for a bit of time now, to not let it lag too far before it gets addressed as a full hearing. So any other members of the board have any comments before we move to close the floor?
And Alder Vander Kessel, I'm sorry, I did it too. Attorney Van Kessel, this is I'm actually going to have to walk back my statement about our ability to compel witnesses. I could have sworn I've seen it in our ordinances, but now I'm not finding it. So I need to do a thorough look through our code of conduct to determine whether or not there's anything provided for in there.
So am I correct? That
May I speak to this again?
Well, just a second. Am I
Okay.
correct that I'm seeing two issues here that need to be addressed, the standing and the witnesses? Or am I missing something?
I think that's generally correct. Although I would make it a little simpler. I guess if I can find out if Mr. Knight is actually an aggrieved party, that would accomplish a lot. And if he has some firsthand knowledge, then I would want his statements of what happened. But certainly statements from the other parties listed. I mean, right now we just have names and addresses. That's hardly the essence of a complaint against my client.
One of the issues under the code of conduct is it does not require an aggrieved party. So that's where the standing issue comes in.
Okay.
I would reference section 8, the code of conduct, paragraph A, filing complaints. So I think that's our starting point as to whether the person who's filing the complaint actually needs to be an aggrieved individual. So those are issues that I think we need an opinion on, and this board needs guidance on as we try to move forward.
Oh, okay, and I'll accept that, but we need some statement by the people that suggest that there was some wrongdoing in what it was, as opposed to conclusory statements. That's my position. That's inherent in the way we at least that my understanding of the way we conduct hearings.
Point taken. The floor is open. Mr. Knight, any response that you would have at this point to these procedural issues, as long as the floor is open?
Can you hear me all right?
Yes.
Okay, excellent. Thanks for giving me a chance to speak to this here. As I stated in the formal complaint, a number of the co-complainants or the people that I've listed here will make themselves available to speak. They are available to testify, and I've listed means to contact them, but I've already organized and communicated with all of these people based on their complaints, their stories. I understand very well how they've been aggrieved, and that's why I chose to help to represent them. And they're all available, and I think that a majority of them will do so voluntarily, if that helps.
All right. All right. Anything further before we move to close the floor?
Well, I'm assuming that Mr. Knight and his group are stipulating that I can conduct a deposition of these people. That's what I'm gathering.
We need to determine whether there's the authority here to have depositions.
I appreciate that, and all I'm saying is that I interpret what his statement to say that they're agreeable to a deposition, regardless of whether you folks feel it can be compelled or not.
Again, what we're looking for is whether we have, as a board, have the legal authority to provide for that. I think if the parties want to volunteer to go through depositions, that's something that you can work out on your own outside of this board.
Okay.
All right. Anything further before we move to close the floor? Hearing none, I will make that motion to close the floor. Is there a second?
Second?
All right, we have a motion and a second. Any further discussion? Otherwise, all in favor signify by saying aye.
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 All right, any opposed? Very good. The floor is closed. So now we're back to trying to calendar and schedule this. As I said, I see two issues here that the board needs guidance on from the law department. That is the issue of standing. And then secondly, the issue regarding essentially discovery in these proceedings prior to the trial. My suggestion before when we were talking about standing was that the parties be given 2 weeks to submit briefs on their position with respect to standing. I think as long as we're doing that, we can also do the same thing for the discovery issue. I don't imagine that's going to be that difficult to address. And then the question would be to the law department as to how long beyond that do you think it would be for your department to get a response and direction back to the board and the parties?
I imagine that we will be able to have something in time for a, I would say give us at least 2 weeks. So if you guys want to plan on having the hearing the first week of September, I don't see an issue with that.
Okay. I don't have a problem with that either. So then let's look at dates for the first week of September. So from my perspective, I'm open that entire week.
My only bad day is Wednesday, the 2nd.
Okay. Anybody else have any issues with that that first week of September? Any dates?
I'm not available on Thursday. This is Alter Vanderleest. On Thursday, I have a county board meeting.
Okay.
Unless you have it, earlier in the day.
Well, we'll try to accommodate that. What about the 1st, Tuesday the 1st? Anybody have any issues with that?
That works for me.
Works for me.
I'm free that day.
5 o'clock?
5 o'clock on the 1st.
And this is Rob Miller, and that would be the trial of this matter before the ethics board?
Correct.
And is that going to be in person, or how is it going to be conducted?
That's a very good question.
I would imagine the city will be having another meeting, council meeting, where the emergency powers will be rediscussed. We've been extending it every council meeting. And should something change dramatically between now and then, there's a possibility it could be the emergency powers would be canceled before then, and we might start in-person meetings. So I guess I would have to say it's all up in the air right now.
I would agree. So we'll have to wait and play that by ear as it unfolds here over the next month.
Well, this is Rob Miller. I strongly request an in-person hearing, even if it has to be delayed. I think it's just better for the conduct of the fact finding.
Well, again, because we don't know yet, it may be possible to have an in-person hearing on the 1st. If not, we'll have to take that into consideration on the 1st.
Okay, I understand.
All right. All right. Anything further for the scheduling with respect to this hearing? All right, so I think that covers this issue for this evening. That would also, since we did not have a hearing, that would address the second issue under regular business, that being the deliberations with respect to the hearing. That would move us on then to the third item under regular business.
Attorney
and that would be
Vanderkast,
for discussion.
if I
I'm
can
sorry?
interject for just a second, do we need like a motion to hold it until September 1st or anything like that? I guess that's a question for Attorney Chavez.
No, by virtue of this, they are filling it for it, so that is the effect of it.
Okay, thank you.
All right. And will, just as a procedural matter, will there be a follow-up notice going out, or will it just be the agenda?
Typically just the agenda.
That's what I thought. Okay, that should be
So I have a
sufficient.
question. Does the complainant understand what needs to happen between now and the hearing time? I just, if he needs to provide things, will he be notified of what he
Are
needs
you
to
asking in
provide? Or-
person?
So the obligations are set forth in the code of conduct, which the parties, at least the complainant, should have since the complaint was filed in compliance or pursuant to it, I should say. And it does state their obligations as far as, disclosing their witnesses and all that stuff.
Okay.
All right. All right, so then let's move on to item number 3 then, and that is for discussion with possible action on revising the City of Green Bay's Code of Conduct for elected officials and the City of Green Bay's Code of Ethics to include provisions that detail what activities are proper and what activities should be prohibited for elected officials in regard to engaging in partisan politics through the use of their Green Bay elected offices. Again, this is a matter that in part has been discussed in the past with respect to amending the Code of Conduct. I don't know that we've had any discussion about the Code of Ethics because I think that's just an adoption of state statutes. But this is something that I would suggest be referred back to the law office for their review and comment back to the board.
I agree. Want to make that a motion?
Could I speak, be open the floor?
Sure. Let's. I'll move to open the floor to allow Alder Burnett to speak.
I'll second.
I have a motion and a second. All in favor?
Aye.
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 Any opposed?
Yeah,
Motion carries.
sorry, I didn't mean to interrupt. Thank you, Chairman Vandecastle. Good seeing you. Just a little background for a few of the committee members who may not have been in the city council meeting last night. We had discussed revising the code of ethics, and Alderman Weary had put a recommendation that it be returned back in September to the ethics board for discussion. So it's sort of an ongoing issue in that there obviously are a lot of things within the code of conduct for elected officials that should be updated and revised. I think many of us would probably agree to that. So what I'm suggesting is that we add some provision, because City of Green Bay government is nonpartisan, the positions are nonpartisan. That's similar to the other 6 sections where there are details on how City of Green Bay elected officials should conduct themselves with the media, with committee members, with fellow aldermen and women, that I think it would be appropriate to put some language in there regards to their conduct with political parties. And this is not a political lightning rod issue for me. It's a sincere belief I've had for quite a while. I just don't want our city government to descend into partisan politics. Everyone has different opinions about that, obviously. So I'm just looking for a discussion. My only fear of referring to the law department is some firm deadline, just out of respect for the legal department. Yesterday, and through the last few weeks and months, they have indicated how far behind they are in a lot of critical things. And as Alderman Galvin mentioned yesterday, not entirely their fault. It's just the work has picked up with not a whole lot of staff increased hours. So I just don't want to refer it there and let it die. I want to have some input into this. It's not my deal completely. I've been receiving comments, dozens, 50 comments probably from interested people, constituents, fellow community members ever since I went public with this idea. So I think that there's a community conversation that has to happen. I think we should have that openly somehow, some way. I just don't want to refer to the law department and have it get lost amongst all of their many other duties. So just a little more of a timeline would be, I think, refer to legal staff, but if you could put some sort of deadline on, so it doesn't have to be September, it could be October, November. I just want to know that it's being worked on progressively.
Fair point. Vanessa, any comment on your part as to where this should go? I know we've had discussions about this in the past.
There's no issue with referring this to staff. My department can definitely look into this. What we would do at this point is look into what others are doing as far as putting limitations on political activity in office. We'd also look at it from a First Amendment standpoint, and we'd bring that research back to you before this board would make a determination as to it wants to move forward with that process. And then we would be looking to you for direction as far as what we should be drafting. So what we have been discussing probably for the last month is the law department workload. And I realize that there's a lot of frustration around how long it has taken our department to be able to get these items in front of the board, especially with the ethics code. And what we have discussed is the fact that it's based exclusively on our ability to get to items. We prioritize based on potential for legal exposure to the city as far as drafting goes. And we have one person who's dedicated to that, who is Attorney Mather. And so, as you can see, Attorney Mather is going to be pretty busy working not only on other items this month, but also on this ethics hearing. And so there is no way that September is a realistic deadline for us to have completed all of that research, in addition to considering the ethics code revisions that are being asked for. And so while I respect the request that we do this in a timely fashion, I would ask that you give us at least a few months before you ask that this be brought back to you.
So, Vanessa, procedurally, it goes back to your office for consideration and drafting of possible changes. What are your thoughts on having it go? Where does it go after it leaves your office? Does it go back to City Council or one of the committees, Council's committees?
Nope, it'll come back to this board. This board is the one that's charged under ordinance with making recommendations for changes to the ethics board or the ethics ordinance. So it would come back to you all.
Okay. So can we then set a tentative date for a future hearing or a future meeting of the board to be involved in that discussion?
Sure.
Okay.
Can I ask one question just so I understand the issue? Is this about, I mean, is the thought to like try to prohibit members who are elected to city government from like going to political party meetings, attending rallies, that kind of thing? Is that what you mean by partisan involvement in politics?
Obviously, there's First Amendment rights, and we don't want to infringe on that. But similar to the Code of Conduct, it details what sorts of activities are allowed or prohibited for elected officials in regards to dealing with the public, for example, or city employees. Like in the Code of Conduct, city aldermen and women are not allowed without penalty or risk of penalty to criticize publicly city employees. So in a similar sense, we could put in a provision that says if a city of Green Bay elected official wants to engage in a partisan activity and use their elected position in that partisan activity, that they do so as an individual and not use their official position. So there are a lot of reasonable things, but quite honestly, we'd have to look at what other municipalities are doing, like Attorney Chavez says. I have a lot of input. I mean, people are reaching out. They don't want Green Bay to descend into partisanship. And And I think a lot of times, and I want to make it clear to this committee, my timing was right after Mayor Genrich's letter to President Trump, which, depending on what your opinion is of the letter, the timing was not a direct response to that. But that certainly is something that we could address in the code of conduct. Like if you use, a city letterhead to discuss a partisan issue or engage in what could be considered partisan activity, that you don't use City of Green Bay letterhead. So again, I don't want it to be about that alone. It's just a number of things. And I have ideas that I would be more than willing to share with the city attorney's office. It's not just my ideas, it's ideas I've been collecting from the community.
Thank you. I just wanted to understand what you were thinking.
Yeah, and I'm not looking for anything combative or destructive. I'm really looking to build up the community to say, okay, engage in partisan politics, but this is what the city of Green Bay, expects of you when you do that, similar to the other 6 provisions of the code of conduct.
Hey, Bill? Bill?
Yes.
Could Alder Burnett forward the emails and communications that he's received from the constituents and concerned citizens to the city staff to give them material to be able to reference with all these different suggestions and ideas? And actually the thoughts behind them then would then probably be better explained?
Yeah. Many phone calls, Facebook posts, things like that, but I would be more than happy to gather them, Alderman Galvin.
Sure, thank you.
Mm-hmm. This goes back 10 to 12 years, so a lot of things I've been gathering.
All right, anything further? Otherwise, a motion to close the floor? Is there a motion to close the floor?
Motion to close the floor.
All right, is there a second?
Second.
There we got a motion and a second. Any further discussion? Otherwise, all in favor signify by saying aye.
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 All right, any opposed? Motion carries. The floor is closed. We're back to item 3 under regular business. And I think we're looking for setting a tentative date for a meeting sometime in the future to address this potential revisions to the Code of Ethics and the Code of Conduct. While we were talking, I was looking at my calendar. I know there was discussion in September and in October. I am gone the first about 10 days or so of October. If we're looking at sometime in the middle of October, is that sufficient time for your office, Vanessa, to address this? Or do we need more
we
time?
can definitely give you an update on where we are at that time.
Okay. So
Could we get an update then in the week of the 11th through the 16th of October?
I'm pulling that date up right now.
Somewhere in that week.
Yeah, I don't see any conflicts on my calendar. So we can definitely find a date that works for everybody.
So yeah, if we get to that point in time and you want to schedule a hearing, then just go ahead and do that, and we'll go through the regular scheduling process to set up I shouldn't say hearing, set up a meeting to discuss this topic and get it on an agenda that's published and posted. So. And
okay.
if more time
I'm
is needed,
thinking it'll have to be that Thursday only because it looks like there are that looks like it's a committee meeting week.
Okay. Right. Well, we'll leave that open at this point, depending on how this goes through your office, and we'll look to set a date sometime in that time frame. So we're not pushing it out too far, but it'll give you some time to address all these issues.
Okay.
All right. I don't think we need a motion on that effect, but anybody else got any thoughts on whether we need a motion to set that time frame? I don't think so. So.
I would say that the proper motion would be to refer to staff with the to report back in October.
All right, I will make that motion. Is there a second?
Second.
All right, we have a motion and a second. Any further discussion? Hearing none, all in favor, signify by saying aye. Aye.
Aye.
Aye.
Aye.
Any opposed? Motion carries. Very good. Next item on the agenda is adjournment. Is there anything further before we adjourn? I don't think there's anything on the agenda, so we are ready for adjournment. Is there a motion to adjourn?
Motion to adjourn.
We have a motion. Is there a second?
Second.
We have a motion and a second. All in favor of adjournment, signify by saying aye. Aye.
Aye.
Aye.
Any opposed? We are adjourned. Thank you all very much for your time and participation this evening. Stay safe, and we will be in touch. Thank you very much.